Hello, and welcome to the Number 5 Planning Podcast. My name is Daniel Henderson, and you join me today at the start of a special two-part series in which we're going to be looking at the practicalities of dealing with Section 78 appeals that take the form of hearings. Now, given the policy framework that we find ourselves in 2025, there are no doubt many of our listeners who will be seeing a significant uptick in appeal work in the coming months. And many of those appeals will, no doubt, be listed by the Planning Inspectorate as hearings. So, to help, in this two-part series, we're going to give you a basic guide for how to do hearings. Some listeners may be very familiar with the format of hearings, in which case this will hopefully serve as a useful refresher of the basics, whereas others may be totally new to them, in which case we hope these are helpful. We're going to do it in two parts. Firstly, in this episode, we're going to look at things from the perspective of the appellant. And secondly, in a separate episode, we're going to look at things from the perspective of the local planning authority. So for today's purposes, from the perspective of the appellant, I'm joined by two planning and environmental barristers at Number 5 Chambers, James Corbet Burcher and Sioned Davies. And I started by asking Sioned just to identify at the outset what sort of case you are going to want to suggest goes to a hearing and how we kick off that process.
First of all, you might consider a hearing where you're developing a smaller scheme, typically where you have fewer reasons for refusal and perhaps there's less public interest than you might ordinarily get with an inquiry.
I think I'd also say at the moment that when the issues are quite narrow and you've got some fairly straightforward policy arguments to make on the basis of the NPPF, that actually many cases that might once have needed an inquiry probably can now be more simply, more expeditiously be dealt with through hearings. They're becoming more and more popular.
And of course, if you need to cross-examine on any particular issue, then you should only really use the inquiry format. A hearing is always non-adversarial.
That's right. And I think it's sometimes a misnomer to think the extent to which you have issues in dispute determines which route you go down. That's not true. Really, the key issue is whether you feel you need to test those issues by formal questioning. It's perfectly normal and perfectly standard to have disputed issues in a hearing, even if you're some way apart. But the real difficulty is whether you're going to need to test them through questioning and whether the basis for your objection is going to need to fundamentally undermine the reasons for refusal rather than simply contest them.
So if you've made that decision to proceed to a hearing, what documentation do you need to prepare? Well, obviously your statement of case, statement of common ground, and the supporting documents. And Sioned, what's your approach when you're starting this process to gathering together that necessary documentation?
So there are two really fundamentally important documents. The first of those is the statement of case. And my advice always to clients is that this should be full, it should be detailed, close to a proof of evidence. Really, that can be difficult, not knowing what the case is from the council, but try and contemplate all of the issues that could arise from the reasons for refusal and make sure you fully explain them in the statement of case. And in particular, pay close attention to what interested parties are saying. Sometimes you might need to commission further expert evidence, for example, on any issues that interested parties are raising. And so it's really important to bear those in mind when you're drafting your statement of case and fully deal with them.
The key thing to remember is that unlike an inquiry, your statement of case is going to be the major substance of what ultimately goes before the inspector in terms of what you've got to say about each reason for refusal. So you're not going to generally have the opportunity later in the day to fill in the gaps. So those gaps need to be filled in at the earliest possible stage, and they need to be filled in as much detail as you can. You want to be setting out as clearly as you can and in as much detail as you can why you say those reasons for refusal are unfounded. I think we probably all agree that one of the most important things to do is get together early on with those who've been advising you on the scheme and flesh out exactly what it is that is the basis of your case as early as you possibly can.
To contrast a statement of case in a hearing with a statement of case in an inquiry, ordinarily in an inquiry context, you would have perhaps a relatively slim statement of case setting out what you're going to say in due course in your proofs of evidence, which obviously isn't the case through a hearing. The upshot of that is that you often have many appendices setting out very fully what your case is.
Absolutely. So I tend to have a statement of case, your main statement of case, and then you have statement of case addendums, which are drafted completely by the individual witness who's going to deal with that particular issue. And effectively, that then stands effectively as a set of proof of evidence-like documents which you assemble at the start and submit. Just to go back on this issue of how do you deal with the fact that you don't know what the case is against you, the same manner as you might do in an inquiry. I mean, one route I certainly recommend at the moment is reminding ourselves, for the purpose of Article 35(1)(c), that the reasons for refusal need to be full, they need to be precise, and they sit alongside the officer's report. The approach I often recommend to my teams is treat the officer's report as if that is the statement of case, and be forensic in your statement of case about how you dismantle those elements of the officer's report that you disagree with. And that will often give you a good anchor point. So don't treat your statement of case as just simply another planning statement. Actually really get stuck into the detail at that point on how the officer's report has dealt with those issues.
Daniel's covering those issues with the team from an early stage. I think it's also important to say that if you're going to instruct a barrister, it's quite important that they're instructed by that stage too.
Yeah, I think that's absolutely right. And in terms of getting the team involved early and keeping them involved, the next stage in the process, once you've got your statement of case in, from an appellant side, is to agree the statement of common ground. And obviously the slightly unusual thing about that process is that it works concurrently with the local authority drafting their statement of case. So from an appellant's perspective, once your statement of case is in, after you've had some time to let the dust settle, I think we all want to be thinking about getting on to agreeing with the local authority a skeletal statement of common ground to begin with, and then fleshing it out with your consultants as soon as possible.
Yeah, absolutely. There's a number of different ways to approach the drafting of the statement of common ground. Is exactly as Daniel says. You can start with skeletal. You can start with something that is a little fuller at the start, which gets narrowed down along the way. You can break it up into different statements of common ground. Every case will have its own particular character. Obviously, bear in mind the PIN's guidance on statements of common ground, which is certainly intended to be a very helpful starting point in encouraging both sides to engage the process. That guidance, and indeed conventional practice, establishes that having set out at the 5-week point what the core issues are between you, if there is further issues that you can get another supplementary statement in on, then you can do those after the 5-week point in good time, hopefully before the actual hearing event.
Sometimes, having drafted statements of common ground and statements of case and received the LPA's statement, it's necessary to produce rebuttal evidence. My experience is that should be limited, it should be proportionate, generally not encouraged by PINs. Is that your experience too, Daniel?
It is, yeah. I think that's why the statement of common ground process can be so useful. I mean, I sort of see it as having two functions, to go back on it before I come back to your question. In the first instance, to some extent, it's a debt clearing exercise. It's setting out very clearly for the inspector those broad topics which are not an issue. So if there's nothing in your case that's got anything to do with flooding, say, or landscape, the statement of common ground is the place to just set that aside and make that very clear. But the second element of it is narrowing down precisely what is between you on those main issues. If you have a landscape reason for refusal, it's very, very unlikely that you are going to disagree about everything to do with landscape, from landscape character to impact to effect. There are going to be areas of agreement. Fleshing those out as efficiently and effectively and fully as you can in a statement of common ground is the way to avoid having to put in too much rebuttal evidence and having to trouble the inspector with that, because you should find, if you've done the statement of case well, that there shouldn't be anything that surprises you particularly once you've gone through the process of agreeing a statement of common ground with the local authority. But yes, I think it's absolutely right to make that point about rebuttal evidence. Strictly speaking, you have no right to.
And so after 5 weeks have elapsed, the authority should be submitting their statement of case, and the statement of common ground must be agreed at that point. What do you do next, Daniel?
At that point, you're really into preparing for the hearing. And I think our collective view would be that once you've received the local authority statement of case, once you're in a position to know what their case is, it's always a good idea to reconvene a meeting with everybody that's working on your appeal team, because it's only really at that point that you'd have had the opportunity to see fully what the case is that you have to meet. You'll have reasons for refusal, and you're right to mention Article 35(1)(c), but not infrequently reasons for refusal won't be as fleshed out as we would like them to be. And so it's only at that point that you can really delve into the detail of it. So the first thing you really want to be doing is setting up a meeting with everybody that's involved, going through that statement of case and working out if, as Sioned says, rebuttal evidence is something that you really absolutely have to do, or working out how you're going to go about doing the appeal hearing and who needs to be there.
And what's your view, Sioned, on who should be there?
Well, I think as many people as necessary to deal with all of the points that the LPA raise. Talking from experience, I've certainly had cases in which local people raise matters which the council don't take issue with. And it's important that you have witnesses to deal with those points should you think it necessary. If there's any doubt about who should be in attendance, I would err on the side of caution and generally bring the relevant consultant to deal with the point.
And one of the most important things is reminding ourselves that hearings are very, very short in comparison to inquiries. And at this stage, if one has that conference shortly after receipt of the LPA's statement of case, some of the conversations one is actually having at that point is, well, what's the agenda going to be like? Are we going to be able to deal with all these issues properly within the hearing timescale? How are we actually going to schedule the issues during the day so everyone knows what their tasks are through that process? Those conversations are really helpful if you have them a number of weeks out from the hearing.
That's absolutely right. I think this is where it's important to remember the difference between the way a hearing will actually take place and an inquiry. In the course of an inquiry, you are very much in charge of presenting your case. Your barrister will call the witnesses that they feel are necessary and will ask them the questions that they feel are necessary. And so you have control over who you need, what you're going to ask them, and when you're going to do it. But in a hearing, as we'll come on to talk about in a moment, you're very much led by the inspector. And if the inspector wants to know the answer to a question and you haven't got the person there to deal with that point, you're in a very sticky situation. And as James identifies, you're not going to be in the middle of a 2-week inquiry where you've got the option to say, well, certainly, sir, we'll bring him in next Thursday for you. It's there and then, or it's not at all. It's probably worth talking a little bit about documents. This, I think, in our experience, is something where there's far more consistency in inquiries than in hearings. But it's really important for everybody to have a system of organising notes and organising documents. I don't know what your practice is in these sort of situations.
Yeah, I mean, I think the position I started out in a few years ago was that everything should be a core document. It should be exactly like an inquiry, all the numbering just as it is in the inspectorate's guidance. In practice, hearings are not designed to have every single document in quite the same way. There is obviously provision for the authority to put in their questionnaire response, which deals with a number of the relevant documents, the development plan and so forth. And there is a sort of a middle ground to be struck between ensuring you have obviously your application documents, your officer's report, the rest of it in one place, and the other sort of common ground documents, the development plan, the SPDs and so forth. I think what's just really important as an appellant in this process is to remember that you're still a full party, still a participant in this process, and you are therefore in a good position to have that conversation with the authority early on, just to check that they've put all the documents they need to in. I know one particular bugbear can be not having the full version of the development plan in.
Yes, I've certainly seen inspectors only ask for excerpts of policies rather than the entire development plan, and it transpires during the course of the hearing that you need to refer to some bit which isn't in the document library. So, yeah, I prefer the whole development plan to be in personally, but
very much so. Yeah, that's what we're told to do by the case law, is read development plans as a whole. Yeah. So it might be thought useful, but I think you're absolutely right to say, James, that a collaborative approach is useful, because ultimately a hearing is going to be useful for nobody if everybody's scrabbling around trying to find the right documents, if nobody knows, there's no sort of clear referencing system for where to find what documents. It's in everybody's interests, most of all the parties who are trying to persuade the inspector that they're right, to have a clear way of saying, going to documents. And that feeds into the way in which witnesses and consultants and people will prepare their notes. And we'll come on to talk about the agenda in a moment. But ultimately, if you want to refer inspectors to documents, which you really ought to be doing as far as you can, it makes it much easier if you know where you're going and if they know where you're going.
I think the other thing to add here is that the opportunities to put in documents later in the hearing process is more limited. Although it's often described as an informal hearing, in practice there are aspects of the procedure which have a greater stricture to them than one might have, again, in the sort of 4-day, 8-day inquiry process, where documents can be introduced, explained, a covering note provided, all the rest of it. In fact, in the hearing process, if you're going to need a document at the hearing event itself, it's very sensible to think about preparing that and submitting that far earlier than you normally would, effectively replicating, obviously, the proof of evidence timescales that one has for a hearing, at least, in other words, 28 days prior to the event starting.
Do we have consistency on how local planning authorities are hosting documents online?
Consistency in their inconsistency. It can be a theme. Certainly most authorities have an appeal section in which they subdivide those documents which are specifically for the appeal. I think it's probably sensible in those contexts then to have all of the documents that you'll be referring to in the appeal within that section, rather than to divide them between the application and the appeal section. But there may be other options to bring it close to the inquiry process of actually hosting all the documents in one place. I don't know whether you feel that's actually something which ought to be moved to as a standard practice.
I mean, I would greatly welcome that.
Very much so.
It's really nice when you are instructed in a hearing and there is a landing page which includes all of the relevant documents, but I realise that's perhaps not general practice for hearings. It's become increasingly common practice for inquiries, but yeah.
So we've filed all of our evidence in good time. We've had our meeting. We've sorted out what our case is going to be, and we know who's coming. Moving towards the hearing itself and the date of the event, the next stage, about a week or so, I think we're generally seeing before the event, we'll get an agenda through from the inspector, and that'll come through pins, and it'll say, here's our proposed agenda. And this is a really important document, I think, we all think, because it tells you, well, first of all, it tells you where the inspector's going, but it also tells you precisely the order in which he or she intends to address the issues. And it gives you the framework for organising your notes and organising the documentation you're going to refer to in one easy place.
I think it's fair to say that the detail of agendas varies greatly. So sometimes they just refer to very broad umbrella terms, landscape considerations or design considerations, for example. But occasionally you get an inspector who has particularised what their concerns are. And that's always very helpful because that gives you a real steer as to how the discussion's going to evolve.
Absolutely. You may even see invitations to parties to agree notes on issues. So not a full statement of common ground, but something which approximates to a sub-issue within a statement of common ground that should be agreed between the parties. And you're often going to get quite short timescales to agree that, often no more than a couple of working days. So you just need to be very prepared in that 10 days in the run-up to the hearing to have to really engage with the inspector's key concerns at that point.
I generally like to have a con the week before a hearing just to make sure that any last-minute issues are dealt with and that we're fully prepared as a team. Sometimes it's been several weeks or indeed months when you've last met the team, so it's sometimes good to refresh everyone's minds and think about what's really concerning the inspector in the week leading up to a hearing.
Absolutely. At that meeting, I often encourage members of the team to write out their speaking notes for the hearing. And that's not a script, it's simply bullet points, key points that they want to get across at the hearing, and so that they can have that in front of them when they make their submissions, make sure that nothing is left behind when they're in the room. Again, it's not for the barrister to review that or curate it in any way. It's purely for that witness, that expert, to have that in front of them as their route map for their submissions at the hearing.
That brings us neatly on to what the hearing itself will look like. They're badged as informal meetings, and I think all of our experience will be that the formality varies very much depending on the inspector you have, depending on the number of interested persons who are there, a wide variety of different factors. But thinking generally, if you have instructed a barrister, and if you've got a barrister and a planning consultant and technical experts, how are we dividing our time? How are we dividing up the way we're putting our case to the inspector?
Yeah, it's a huge question as to what the limit should be on the barrister making submissions, as opposed to obviously the planners and the other specialist experts. It is tempting as an advocate in a situation where we only ever get to ask questions to give the answers ourselves, but most of us understand, in line with the PIN's guidance, that our role there, as the PIN's guidance described, to be the team captain, essentially is to deal with the narrow points that we as barristers can assist on: legislation, policy interpretation, perhaps the issues which arise, for example, from similar appeals within that authority or on similar points. And then it really is for the experts to deal with the substance of the issues in that particular case.
I think sometimes a barrister is useful in breaking down questions, particularly where questions might contain multiple component parts which engage the expertise of multiple different individuals on the team, and helping to ensure that the question has been fully answered, making sure that the inspector is satisfied with the answer that they get from someone in your team. I also think a barrister is potentially very useful in a hearing context in helping to really set the narrative, focus on the best points, and really ensure that the story you're telling as an appellant is a compelling one.
Yeah, I think that's right. I think it's also important, though, to bear in mind, particularly as barristers who like the sound of our own voices, the importance of deferring to experts where needs be. And if you are an expert witness who maybe hasn't given evidence at a hearing before, or who has given evidence at an inquiry before, but not a hearing before, sort of our general top tip is that there's not really any magic to it. Because we're not having formal presentation of evidence, where you're having to respond carefully to questions being put by a barrister and bringing your evidence out slowly and carefully. Really what you're doing is you're conveying information to an expert tribunal who understands these issues and who's done these things many, many times before. It's often, in my experience, a concern of witnesses appearing at hearings that effectively they're being asked to give a sort of free-form speech about their area and the issues that arise. An important thing to remember is that there really is no magic to it. You're simply explaining your professional opinion about the issues that arise to somebody who has asked you a fairly precise question about that.
And this huge theme here is about simplifying.
Yeah.
Simplify what your task is. I often, when I talk to consultants who are beginning this appeal process, concerned about all the different issues they might be dealing with at the appeal hearing, they're a bit like Benedict Cumberbatch's Sherlock Holmes' mind palace, swirling different ideas around them. And I say to them, look, put down the mind palace, basically set out on a single piece of paper, what are your objectives for this hearing? Just literally single sentences. So 1, to confirm that it complies with this policy of the development plan. 2, to confirm that we've addressed issues which arose in the earlier application, which was refused, and this is our second application. And the test to apply, always in preparing your evidence, is what can the inspector actually record in the inspector's report? You know, in a world which we are, in many cases, have very complex narratives and different exchanges and conflicts and confrontations with the authority on different points, what we need to remind ourselves as professionals throughout is that in the decision that's issued, that particular main issue will be dealt with only a handful of sentences. So if you start writing your hearing speaking note on that basis, this is what I'm going to address, then that will help you identify what's really important and cut out what is just distraction.
Perhaps it's worth saying something about the back and forth, as it were, between the counsel and the appellant at a hearing. Typically, the inspector will ask a question, will ask normally the counsel for their view, they'll come back to the appellant, they may go back to the counsel for a second view, and then they'll come back to the appellant. Ordinarily, the appellant would have the last word, but it's important that witnesses are familiar with that. They might think they've said their piece and that's that, but it's important to be agile and be able to kind of respond to points on the hoof as and when they arise from the other side.
Absolutely right, and I think that arises from what you were saying, James, about the decision letter, and that's really where the inspector's agenda comes in. If you've got a good detailed agenda, inspectors in advance of doing their reading into cases will know the points that they feel they need to address in order to write a coherent decision letter that takes them to the point of reaching a decision. And so questions that are asked of you are going to be with that in mind. They're going to be seeking particular bits of information. They're going to be targeted and they're going to be specific. And that's why that agility that you mentioned is so important.
Let me just add some other important issues as the appellant's witness, things you need to be preparing for from the outset. At the opening, the inspector will ask you to confirm the plans on which the decision was made. It's often helpful. They may be already listed in the Statement of Common Ground, but to have a very specific note of those so you confirm when those numbers are read out. And alongside that, a separate sheet confirming any additional documentation that's been sent in, particularly if there's been a run of different late submissions, inverted commas, so that you can just confirm the inspector has what exactly they need, confirm that nothing's been left out. Something else which can arise quite early on is an itinerary for the site visit. In many cases, the inspector will already have visited the site, but there'll be a post-hearing site visit, and you probably should have sent that through to the inspector beforehand if it can be agreed with the local authority. But if you haven't had time to do that, just prepare one and you can easily hand that up to the inspector at the outset. Anyone else have any sort of ideas about other sort of procedural quirks, as it were, which aren't stuff that's not written in the manual, but which can, as it were, help you have an easier experience on the hearing day?
I think one thing to have firmly in mind, not least because it often appears right at the end of the agenda, is the importance of conditions and if there is one, a planning obligation and what that looks like, because you've come from off the back of an officer report that's recommended a set of conditions, not to engage with those until the last minute. But it is inevitable that you will get questions from the inspector about particular elements of the conditions. The nature of the appeal process, as those who've done inquiries will know, is that these things tend to get far more scrutinised at appeal than they ever are at committee. And so I think it's worth really turning your mind in that week or two before the inquiry very, very carefully to those conditions, why they're there, what they're doing, what your position is if you're asked about their necessity, particularly as an appellant, because this is your opportunity to highlight for the inspector if there are conditions that you feel are unnecessary, if they're not doing anything, if they're adding something that's not planning related. I think that's worth thinking about well in advance.
I think the other thing is that often it's helpful to have printed copies of either important plans or documents which are particularly visual. So that might be the LVIA, for example, it might be landscape management plan. I think having those documents in hard copy helps with the show not tell aspect of a hearing, which means that it's easier for an inspector to visualise what's going on than it is to just refer to kind of the written text of the LVIA, for example.
Very much so. So should we finish then with some top tips as to how to do hearings? Summarising what we've done before, I think my top tip, because I'm going to steal in with the first one, is the importance of early engagement with the full team. Sitting down for a meeting, for a conference with whoever's going to be on your team as early as you possibly can, understanding the basis of your case and understanding the core information and documents you need to get before the inspector as early as possible.
You need to think very carefully about the weakest parts of your case, because those are the parts of the scheme that the inspector will ask questions about and will want to kind of know a bit more. So if you're prepared to deal with those tricky points early on, you're likely to be more successful in a hearing, I would suggest.
And I'm going to fuse both of those things together by saying start at the end.
Yeah.
One of the quirks of the hearing process is that you are told early on the identity of your inspector. There is available through Compass and through other resources a list of appeal decisions that inspector will have decided. By checking that list, whether it's written reps, hearings, inquiries, searching through those to understand how that inspector has dealt with similar issues will help you start to look at decision letters that they have written. And if you also look at similar decision letters on the same points, then you will start thinking about where you want to get to at each individual stage. To repeat a point I raised earlier on, remind yourself that most main issues are settled in relatively short blocks of text in which the key rival positions are set out and a short summary is provided of those issues. And that's where you begin to think about what's really important and what matters in the very surgical process of doing a hearing on the day.
Brilliant. Thank you both very much indeed. Well, there we are. We hope that was a helpful canter through the basics of how to do a hearing from the perspective of the appellant. But as I said at the opening of this podcast, this is a two-part series. So join me next time when we're going to do the same exercise, but from the perspective of a local planning authority. See you then.